WDXE for spinning on Cowboys quarterback Dak Prescott in a game that also had a long lightning weather delay. Philadelphia ended up winning. The Philadelphia Eagles defending Super Bowl champions beat Dallas 24-20. I'm Dave Anthony, and this is Fox News.
Lawrence County depends on WDXE News, on the air since 1951. Legend, 105.3, 95.3, WDXE.
And once again, we made it to Friday, and it's time for Bulletproof Estate Planning with my friend Stan Pierchoski, Pierchoski Estate Law in Pulaski, Tennessee. How are you, bud?
Good morning. I'm here. My mic's
You are here. Mic's a little hot.
Yeah.
It's probably your headphones.
Oh, okay.
It's probably your headphones more than the mic.
Anyway, good morning.
There we go.
I'm fine on Friday. We are here again on Friday for Bulletproof Estate Planning.
Yeah.
And it seems like we were just here.
It seems like we're just here.
It was sort of a shorter week, I guess. We had Monday off, so.
You know, we did have a short week.
Yeah.
Yeah, had a short week. And did you all get to do anything for the holiday
We
weekend?
didn't really have anything special planned.
Yeah, well, we didn't either much, but enjoyed being off a little bit.
Sure.
Yeah,
But,
sure did.
all right, so I got a few things I want to talk about this morning, but first off, I want to begin with we got a seminar coming up.
Yes.
And it's coming up, a week, 2 weeks, the 20th. So it'll be 2 weeks from tomorrow.
Okay.
And it'd be right here at WLX radio station in the back of the building. And we do that on that Saturday. We're going to do it at 10 o'clock in the morning.
Yeah.
We call it Wills, Trust in the Nursing Home. And that's what we talk about. And we don't really go into a deep dive because it's about an hour, a little longer than an hour long. And then we always set aside as much time as is necessary to answer questions. Sometimes I'm there a long time answering questions, which I don't mind. So if you have a question, if you want to come to my seminar, I would encourage it because it's a lot of good information, and it'd be a lot of information you may not have heard before. And when you don't, even though you didn't hear of it, a lot of it will be very attractive to you.
Absolutely.
And so you might want to give it some thought. So we just call my office at my Pierchoski Estate Law, which is at 931-363-7222, and you can get on our RSVP list for that, which is pretty loose. We just like to know how many are coming. And, I'll bring that up again at the end of the hour. So
Great.
But again, remember, this is a call-in show or interactive show. And although I usually try to have a topic every Friday, we certainly will entertain calls on any topic.
Sure.
All we ask is that somewhere hovers around estate planning.
Somewhere hovers in the estate planning arena,
That's right,
yeah,
that's right.
absolutely.
But anyway, since it is a call-in program, the number is 766-9393.
That is correct.
766-9393.
That is correct, yes.
And, I was listening on the way over, and I didn't hear the end of Joe's story. Last I heard, he would park the truck and took a nap.
Well, that was kind of the end of it. We were talking about being hypnotized,
Oh,
and of course, what had happened to him, I think he got to concentrating on the snowfall in a night drive and kind of faded out.
Oh, okay.
Zoned out in it and kind of lost where he was.
Was the truck beside him any significance?
The truck he thought was trying to help him.
Oh.
And kind of recognized the fact that he must not be awake.
Or he's still driving.
Yeah, so and he's still driving. Kind of reminded me of that scene in Planes, Trains, and Automobiles.
Oh, yeah. Yeah.
Where they're on the wrong side of the road.
And he spins out, goes off the exit, spins around and lands right in the parking lot of a hotel, right somewhere in the parking place, right?
Yeah.
It's almost like Pee Wee Herman. I meant to do that.
I meant to do that.
So, yeah. Well, we had a pretty good week. It was a short week. It was a good week. We had some interesting things happen. But what I want to talk about, there's a couple things. I talked on one of my other shows that I do about this concept of step up in basis. And I might do that on a Friday morning.
Yeah.
Because it gets a little heavy, but I get the question all the time. And it seems like for the 100th time I get it, and I thought I might just discuss it a little bit.
Yeah.
A step up basis is an important thing. But the bottom line is, on the other show I kind of went into that revenue ruling, 2023-2, that talks about that and how it's misunderstood. We talk about what it actually says and what it actually doesn't say. And if you put property into the trust that we do, the irrevocable trust that we do, the asset protection trust, you do get the step up in basis. If you're reading that revenue letter or your CPA tells you, hey, all irrevocable trusts don't get step up in basis, that's been changed.
All right, you
That
may
is
have
not-
to-
That's not correct.
You may have to go to the basics with some of us and explain what a step up in basic is.
I will, that wasn't the topic, but that's all right.
I don't-
That's why I started it, I let the cat out of the bag.
You let the cat out of the
Well,
bag.
you're in real estate, so you'll understand this. First of all, let's start with what a basis is.
Yes.
It's called a tax basis.
Yes.
We call it basis, but they really mean a tax basis. And let's say you have a piece of property, and you bought it 10 years ago.
Yeah.
And you paid, and on radio, I like to keep the numbers as straightforward as I can. So
Right.
you buy a piece of property, you pay $100,000 for it. That is your tax basis, basically what you paid for it.
Right.
Now, if you keep it for 10 years, and let's say now it's worth $200,000, okay? If you sell it, okay, you will have a $100,000 capital gain.
That's correct.
Because the capital gain is the amount of money you pay over your basis.
Yes.
Okay? Now, I didn't say capital gain tax yet, because you may or may not owe the tax on it, because you only owe the capital gains tax if you realize the gain. Now, what realizing the gain means is you keep the money.
Yes.
Let's say you sell for $200,000, you put the $200,000 in the bank, 180 days later, 6 months later, you still have the money in the bank. Then you have realized the gain, and now you owe tax, and now the capital gain tax is due on the capital gain.
Yeah.
The capital gain in this example is $100,000. Now, if you give it away during life, let's say you say you know what, for any reason, a lot of people do it because of long-term care, but I'm just for any reason, you say, I'm gonna deed this to my son now.
Yes.
So you do a quick claim deed, it says, for love and affection and token consideration of $10, here's the deed. You give it to your child.
Yeah.
When you give that to your child during life, it's because there's no bargain for sale or exchange, there's no way to calculate a new basis, so you have given your child your tax basis.
Yeah.
So if they go and sell it the next day, you've just handed them a $100,000 capital gain liability.
Yeah.
Okay.
Yeah.
Now, that's kind of a disadvantage for them. But I mean, sometimes if that's what we do, it's what we do. If that person just keeps it and puts it in a trust or something and leaves it to their kids after death, it'll kind of cure itself.
Right.
But now, when you put property in a trust, or basically when you leave it to people after death, okay, what happens is they will get a step up in basis. What that means is their basis, so leaving it to the child, same child, leaving it to the same child, but you're not giving it to them until after you pass away.
Okay.
In some testamentary instrument, like a trust or a will.
Yes.
They will receive a step up in basis, meaning their tax basis will now be the fair market value the day of death.
That's right.
In this example, at death, their tax basis is going to be $200,000. So if they turn around and sold it right away, there'd be no gain. But if they kept it for another 10 years and went to $300,000, they'd have their own capital gain.
Right.
But it would have started from the stepped up number.
Yes.
And so it's a big deal. Now, this revenue ruling says, well, the revenue ruling doesn't say it, but the mass interpretation of it is that it changed the rules and did away with it if it's an irrevocable trust.
Okay.
And our asset protection trust is an irrevocable trust. And that is not so. It didn't change anything, it's just reaffirming what, and I don't want, I'd rather get into it on another show because there's a little more explanation involved. But what the revenue ruling is making a distinction between income tax purposes of property in the trust versus estate tax purposes for property in the trust. And
Yes.
There's a big difference between two. So, but the bottom line is, without getting too deep in the weeds, the bottom line that people need to know is the irrevocable trust that we do for asset protection, you do, absolutely positively, you get the step up in basis, which is
Okay.
what we want.
Okay.
Now, there are certain kind of trusts where you don't, where you completely divorce yourself of all ownership criteria, and that's sort of what it is. We don't do that with these kind of trusts because we keep them what they call tax inclusive into the estate at death, and that's what we want, and that gives us the step up in basis. So
Okay.
that's the bottom line is with the things we do. So if you've done one of my trusts and you're worried about that, or you have heard about it, and you want to do one, maybe we can sit down and talk about it some more because it is in fact preserved. Step up in basis.
Interesting
Stuff.
stuff.
It's a big advantage. So
Yeah.
we want to make sure we do that, and that's in how you write the trust. So.
Very good that's good information for people that maybe hadn't thought about it, don't know about it, don't know quite how that
Well,
works.
It usually comes around, I have a tax person or a CPA person, they'll tell their client, hey, this you don't get to step up in basis. And I've actually got some of those documents in, on my computer where the actual sentences and lines are highlighted.
Yeah.
Because I send it to them, and I've done it on many occasions.
Yeah.
And, after I send it to them and we talk about it, I convince them of what it's really saying. But, tax ruling, tax revenue rulings are usually worded pretty, what's the word I'm looking for?
Yeah.
Not very inartfully drafted.
Okay.
You think they just say what they mean, right?
Right.
It's not like a letter from Aunt Gertrude where she just tells you something. It's you have to extract the meaning. Don't ask me why.
I think they do that on purpose.
I think so too.
That gives the lawyer something to interpret.
Maybe that's the reason. I don't know. All right, so what I want to talk about is something right down your alley. Which
Okay.
is,
I like things down my alley.
ownership of property.
Yes.
It's a confusing thing too. And again, I'll try not to get into weeds too much, but sometimes it's hard not to. So, really, and the reason it's important is because whenever we do a trust, whether we do a revocable limit trust or the asset protection trust, or even some of our special needs trust, what we like to do is move the real estate into the trust. Now, what I'm referring to is real property. When you hear the word real property, it's talking about land. Basically, it's defined as land and everything that's permanently attached to it.
Right.
So, there's no such thing as a deed to my house. There's a deed to the plot of land that it's on, and your house is just attached to it. When you own property in Tennessee, we almost exclusively move it into a trust. That's a big ticket item in the estate, especially in our asset protection trust. We want to protect that property, so we want to
Right.
get it into a trust. And we put it in the trust. We retitle it to the trust. We just change the ownership. Change the ownership from Stan and Tammy to Stan and Tammy trustees of their trust. Right. That's all it takes to put it in there. A new deed.
Yeah.
But I want to talk about how you can own property in Tennessee. There's only 3 ways. Okay? There's only 3 ways you can own property in Tennessee. So I want to go over some of those. And some will sound familiar, and some might be news to you, but I think it's interesting. But then, I'm a geek. But it's concurrent ownership, and that's what I'm talking about. Concurrent ownership. If you just own it as an individual, it's pretty straightforward.
Yeah.
But concurrent ownership, it really recognizes 3 different terms. Tenancy by the entirety, you probably heard that line. Joint tenancy with right of survivorship, and tenancy in common. Those are the 3 ways to do it. So let's talk about tenancy by the entirety. That's probably how a lot of people own property, but may not quite understand what that means to them. Now, tenancy by the entirety is only available in the state of Tennessee. It's only available to married couples. Okay, so if you have a deed, and I'm going to use you for an example,
Yes.
Jeff and Teresa.
Okay.
If it says Jeff and Teresa, husband and wife,
Yes.
even if it doesn't say anything more, there's like a default value. You guys own that property as tenants by the entirety with right of survivorship.
Yes.
Now, you could say it. It could say Jeff and Teresa, tenants by the entirety with right of survivorship. But it's not necessary to say it. If you are married as husband and wife, that's the way you own it by default.
Right.
Now, you could say you own it a different way if you wanted to do that. You could say Jeff and Teresa as joint tenants. I mean, that's rare, but it's possible.
Yes.
So, but the takeaway is you own it with this right of survivorship thing. And you don't even have to say the words in the deed because that's the default value. Now, you have to be married when you acquire the property. If you were boyfriend and girlfriend or engaged and you bought the property and then got married later, you don't get it. It has to be modified.
Okay.
So, but now let's talk about what tenants by the entirety, because the words have meaning. When you say it, it's just words, but they actually have meaning. With the right of survivorship, what tenants by the entirety really means, when you think about it, you think, well, that's my half and your half, husband and wife. There is no half when you're talking about tenants by the entirety.
That's right.
Yeah, both parties own all of it.
That's right.
It's kind of a weird concept, but they own it all. And they own it all because of the marriage, because of the union. So, we have this thing when we convey property, we call them the 5 unities, okay? The 5 unities are interest, title, time, possession, and person, okay? Now, under the person thing, if you're husband and wife, you're considered a single entity.
Yes.
The marriage, the couple. Tenants by the entirety, you both own all of it. Nobody owns their half or anything. There's no fractional division.
Right.
And so now the right of survivorship that comes to play the right of survivorship, so, you know, we always kill the husband off first in my office, in
Yeah.
my example. So, Jeff, if you're the first death,
Yes,
at the moment of your death, at that very moment, all ownership of your property vests with the survivor.
yes,
So, I mean, you don't, and so a lot of people say, do I need to do a new deed to show that, you know, Teresa comes to me and says, do I need to do a new deed to show that Jeff is no longer there? I said, no, there's no need to do that. I think you could, but I wouldn't recommend it, no need.
yeah,
We'll deal with that next time it gets conveyed.
Yeah.
But all ownership vests with her at that moment.
that's right,
Okay?
that's right.
And so, you know, sometimes you'll hear me say, at the first death, you don't have to probate land. But at the second death, you do.
Yes,
You know, because remember, if it's in your name, it's goes through probate. So if you pass away first, it just vests with her. No
That's
probate's
correct.
necessary. But at her death, if she now owns it in her name, and there's nobody for it to go to. Now, so this right of survivorship, you can have, you know, that's husband and wife is the default. Now the question is, can you have right of survivorship with a non-spouse? And the answer is yes. Now
It
you'll
is.
when you research this, if you research it, you'll find things where it says Tennessee does not recognize tenants by the entirety or right of survivorship with a non-spouse. But there is such a thing. And
Yes.
there's some court decisions that say you create it, but now in the deed you got to say the words. So let's say you and I decide to buy a piece of property together. We can
Yeah.
say we Stan and Jeff, tenants by our tenants in right of survivorship.
yes,
Okay.
with right of survivorship.
Tenants in common. I mean, joint tenants, not tenants in common.
Yeah,
And so we have the right of survivorship, but to get it, we have to put it in the deed. The words
Yeah.
have to be there.
yeah,
So we have to create it. And of course, when you're talking about right of survivorship, you can have more than just two people. I mean, I guess
True.
you have 10. One passes away, now you have 9. Now remember, again, you don't own a 10th and then you own a 9th. Let's say you're the last person. You don't own a 10th and then a 9th and then an 8th.
Yeah.
And then a 7th, as it goes. You have 10 owners that own everything.
Yeah.
One person passes away, you got 9 owners that own everything,
Yeah.
8 owners that own everything, and so on. And you get down to the last one, and then there's no survivorship provisions anymore.
right.
So, you know, it's possible to do it with a non-spouse, again, but you gotta say the words. That's what's important about that.
Yeah,
And you may see that in some of your deeds, I don't know. But, let's see, I made myself some notes here. Now we want to talk about fractional ownership or tenancy in common. Okay, that's when you own property with someone else. And I call it fractional ownership. And a lot of times you'll hear, you own 2 people own it, like, you say you and your brother. So you
Yes.
have, you know, brother 1 and brother 2, each with an undivided 1/2 interest. Okay, now you do own a half of it. Now, but the thing is, there's no line drawn down the piece of property. It's not like this is my side and this is your side.
that's correct.
Because when you own it this way, you have what is called equal right of possession and equal right of entry.
Yeah,
Which means, I mean, as odd as this sounds, what it means is brother A can do anything he wants with the entire property. Brother B can do anything he wants with the entire property. When this comes to problems, when what they want to do with the entire property is inconsistent with each other. So
That's correct.
brother A wants to grow corn and farm it, and brother B wants to build an amusement park there. Those are inconsistent uses of the land, right?
That's correct.
Okay, so, but what it means is that you have full use of it, but if you ever sell the property, you get half the proceeds. So it's 1/2 undivided interest. Now you can have more, you don't have to be 1/2. But if it just said brother A and brother B, the default is 1/2. But if you wanted something different, you could say brother A has 7/10 and brother B has 3/10. I mean, you can have a unequal division of proper fractional ownership. But, I mean,
Right.
but see, but the owners have to be in agreement with that, of course.
yes,
But you can have that, and we see that
Yeah.
sometimes.
yeah,
We do that sometimes with our 10-care planning, where we can put somebody 99% owner and somebody else 1%, 1/100% owner.
Yeah.
So,
yeah,
and now the difference between owning this undivided interest is it's an inheritable right, it's a transferable right, and it's a divisible right. Meaning, if you and I own a piece of property as
yeah,
each 1/2 undivided interest,
right,
if I pass away, it doesn't go to you. It's an asset I have at my death.
that's right,
And I can leave it to my kids.
That's
In
right.
which case, you would own a piece of property with my kids.
that's right,
Or if you pass away, and then my kids might own a piece of property with your kids, if that's where you left it.
yeah,
So it's something you own, and you have it at death, where, compare that to right of survivorship, it disappears at your death and goes
Yes.
to the survivors.
Yes.
So, big difference between the two, really.
Yeah.
Really, the big difference only comes into play until somebody passes away.
Yeah, yeah, exactly.
So,
Exactly. I ran into a circumstance a few years ago where a property was jointly owned, and one of the owners couldn't get it through his head that he didn't have, let's just say it was 10 acres, and he owned it with 5 other people. He said, "Where's my 2 acres?" And I couldn't get it through his head that you don't really have 2 acres. You have the whole, and y'all all own the whole together. And that's just an example of what you're talking
Oh,
about.
no, and it's an odd concept.
Yeah.
It is an odd concept. Let me just read something. Tennessee recognizes that property can be held by co-owners as tenants in common.
Yes.
Tenants in common are jointly seized of the whole estate, and each have an equal right of entry and equal right of possession, and each share the benefits and burdens of ownership. So they do. You own all of it, but you have use of all of it. But when it comes to the value, you only own your share. Like if you sell it,
Yeah.
you only get half the money.
Yeah.
Yeah, there's no line drawn down the center and says, this is your half and this is my half.
That's correct.
I mean, and some people do that, but when you do that, then you can bifurcate them both into deeds. And now,
Yeah,
but now the person owns the whole thing, which is their half.
They become separate
That's
pieces of
right.
property.
That's right.
Right.
And these ownership formations these are things that are firmly rooted in our common law jurisprudence. I mean, we brought this type of ownership here, from England when we migrated here. They've been around forever. There's nothing new under the sun. As a matter of fact, my document is some stuff I took out of something I've written some years ago, and I quote some court cases that establish these things. And the one I just read you was out of a court case out of 2017.
Right.
But it cites a court case from 1835 and another court case from 1828. So, it's been around for a long time. So that's what we do it. Now, that being the way you can own property, those 3 ways, let's talk about deeds, and the different kind of deeds you can have.
Okay.
And actually you can have 3 kinds of deeds. You can have a general warranty deed, you can have a special warranty deed, or you can have a quitclaim deed. And all are deeds, but they're different kinds. Now, general warranty deed is the kind of deed that you would want to have if you purchase a piece of property, especially if you purchase it from a third party. Like, say, I want to buy a piece of property, and I buy it from somebody was advertised, and I never met the person. I don't know them from Adam, but I want to buy their property.
Right.
I'm going to want a special warranty deed, because I want to make sure the title's good.
Yeah.
And I'll have a 30-year title search done, see what encumbrances are on the property,
Right.
stuff like that. I want what's called the covenant of season. The seasonship of covenant is the right. It's pretty much the person says, I have the ownership and I have good title to sell this to you.
Right.
We want the power we want to make sure they have the power and the authority to convey. We want a warranty against any encumbrances. If there's anything out there that isn't disclosed by a title search, we want a guarantee that to protect our title to the property. And so those are the things you get with a general warranty deed. They cost a little more to do because there's a little more behind them.
Right.
And typically when you buy it from somebody outside the family like that, that's typically what you want, because you don't know the history of that land.
Yeah.
Technically, you certainly don't know the legal history.
Right.
Now, I'm not going to talk too much about special warranty deeds. They're pretty popular with commercial transactions. We don't do a lot of it, every once in a while.
Yeah.
But the quitclaim deed is something we do a lot. Quitclaim deed, like I said, the deeding that I do is putting property in the trust.
Yes.
Or at death, taking it out of the trust and distributing it to people.
Yes.
We do all of that by quitclaim deed. Now, quitclaim deed doesn't have any of these. It's very popular among related parties. So if you ever want to deed a piece of property to your kid, let's say, we do it by quitclaim deed, because what we're saying is, there's no need to do a 30-year title research. We're passing this to somebody else in the family. We know all about that. There's no need to do all this. We know the encumbrances that are on this.
Right.
So a quitclaim deed, it reminds me of a sticker on a car when it says "as is."
Yeah.
You know what I mean? Basically, you're saying, hey, whatever right, title, and interest I have in this, or whatever encumbrances or obligations that are in this property, I'm giving to you. So it's a transfer of ownership.
Yes.
Right? And like I said, they're easy because we don't do the title search on those. And quitclaim deed is a unique animal. Not very, it's very common in Tennessee. We do a lot of them.
Right.
And there's something, now there's the kind of deeds we do. It's, a lot of people say, well, you know, they ask about what's the difference, what's a quitclaim deed? Quitclaim deed is a deed, now, no doubt about it, you are conveying property. And, but it's a simple way to do it. Now,
Now, help me with this, because this is the way I've had it explained, and I maybe have this wrong, because a quitclaim deed is, I am giving, in the quitclaim deed, if I'm giving a quitclaim deed to you, I'm conveying whatever interest I have to you.
whatever that is,
Whatever that is, and I may not even have any.
that's true. Okay, good point, good point. I wasn't gonna go there, but I know exactly where you're headed.
So, because I've had this happen.
Yeah.
You know, we've talked about this in other circles.
Let me tell you where that happens and why it happens.
Yes. I think it's interesting.
Sometimes it doesn't need to happen.
No.
But if you don't know, it's kind of an error on the side of caution.
It is.
what it is. So let's say, you know, something that, you know, remember I talked about if you pass away, you own this piece of property, you can go to your heirs.
Yes.
Well, you just go through one or two generations, and you end up with a lot of people in that group
That's
of
right.
people, right?
That's right.
Okay. Or it can get big fast. Okay. Now, a
Yes.
piece of property gets sold,
Yes.
and they go through the title search.
Yes.
And we have these people that may or may not have an interest in it.
Right.
And some people, bottom line, if we know the person has an interest in it, and we go to say, hey, we're trying to, you know, will you give up any interest you have in this so that we can sell it to this buyer?
Right, right.
And if they say, yeah, it's okay with me, they'll have them do a quick claim deed, says, you know, we don't have to go in and say, okay, I have a 1/32 interest because of this person passing and leaving
Yeah,
it to here.
yeah.
They're just saying, whatever interest I have, I'm giving up.
Right.
And what that does is now they can, usually the title insurance company can now insure the title because that person's not gonna turn into a future claim.
That's exactly
Now,
right.
you may run into people that are somewhere in this chain, but you can't completely nail down if they have any ownership or what it is.
Right.
And this, again, I see this, it's common when you get a lot of people involved. They will reach out to people and say, well, you sign a quitclaim deed. I mean, it may very well be that they have absolutely no ownership or no interest in the real estate.
Right.
And they say, we want a quitclaim deed just saying, whatever I have, if I have any or not, I'm giving it up.
Yeah.
So that's why they do it. It's kind of like, and it's not a bad practice.
It's kind of cleaning up the chain of title.
That's right. It's right, and it's not a bad practice. But sometimes, I mean, if you absolutely positively know the person does not have an interest, I think it's pointless to have them do the deed. But
Yeah.
a lot of times they just do it anyway.
Yeah, yeah.
But it's you know, you got to understand what they're trying to do. Like you said, you're trying to make it so that somebody can't raise a claim down the road.
Sure.
And say, hey, back here I have this interest when Granddaddy left it to me, and I didn't know I had got it, but now I know it was part of mine, and I never gave it up, and so that's cloud on the title.
Yeah,
And
but
that's what.
but if I could talk you into giving me money for a quitclaim deed to the public square,
Yeah.
or a piece of property that don't have anything to do with whatsoever, then I'm a crook.
Well, I mean, if somebody came to you and said they want you to sign a quitclaim deed for the public square that you have no interest in it,
Yeah.
there's got to be some thought process behind that.
Yeah.
And I can't. If that's the case, then they have to talk to everybody.
That's right.
If there's no thought at all, and they come to you about it, then they
That's
got to
right.
talk to everybody.
They're going to talk to everybody.
And but I mean, there might be, if somewhere in the chain of title, there's a possibility that you might.
Yeah.
Something like that.
Yeah,
And again, some people refer to their property as heir property. Heir meaning H-E-I-R, right?
Yes.
And when a couple generations go by, I've had ones where I was into like the 125th of the property.
Oh my gosh.
Oh, it was just, it was everywhere. And there's a lot of people who got to get involved in that.
Yeah.
And so it's hard for a title company to insure title when they can't identify all the predecessors in title.
Yeah.
Because, as a chain of title, you own it, you sell it to me, that's it. You don't have the property anymore, you don't have anything to do with it. You can't later on say, well, I want to make a claim on that. You've sold it to me.
Right.
But if there's somebody, I don't know, in the wings there that had some interest and they didn't agree to sell it to me, now they've got a claim on that property as a cloud on the title.
Yeah.
So it can get cumbersome.
It can. It surely can. And that's why we have to hire lawyers and title companies to clean that up.
Yeah. Not always, but yeah. That's what they do, but yeah, that's right.
Try to, anyway.
But let me talk about this when you have a deed in Tennessee. When you have a deed in Tennessee, you don't have to record it. People, everybody does it. I think it's a good idea.
It is a
I think
good
you
idea.
should. But there's nothing says you have to. Okay. Now, here's the problem, if you don't record your property, and you have a deed that the owner signed conveying it to you, you darn sure better not lose that document, because that is the only thing out there that shows your indicia of ownership.
Yeah,
That's the only way you can prove it.
yeah,
So you might want to hang on to that keep that one close to the vest. But if you record it, it doesn't matter if you lose the original deed, it's now in the public record.
yeah,
But when you record a deed in Tennessee, when you convey property, and so we talked about all the different ways you can own it, we all talked about all the different ways you can convey it and different kind of deeds. When you transfer property in Tennessee, they're gonna wanna hit you with a transfer tax. Now, I'm not talking about your every February 28th tax, that's a ad valorem tax, that's different. But a transfer tax is, they're taxing you just because it's being conveyed. Actually, they're taxing the new owner. And it's a pretty healthy tax, it's $3.70 for every $1,000 worth of value.
yeah,
So if you got a $100,000 piece of property, which isn't much of a piece of property, but I'm just saying, you got a $400 bill in just in the transfer tax.
yeah,
And so, but we have a statute in Tennessee that can exclude certain people from that tax. Now, a lot of people say, well, if you give it to your kids, that's excluded. Well, that's not exactly what the statute says. But there are certain places you can send it. One of the things you can send it and exclude it from the tax is a revocable living trust.
okay,
You can do that. And you really need to put the language in the trust, I mean, not the trust, in the deed that says that, in the deed, okay, this is an exempt transfer under the statute, the recordation statute, and say, this is exempt under this, and we usually cite the statute and the section.
yeah,
Now, when you can also avoid the transfer tax with a quick claim deed. There's a section in there, because when the statute says when you transfer property to a revocable living trust, no transfer tax. But it uses the words revocable living trust. When we do our asset protection trust, it's not a revocable living trust, it's an irrevocable living trust. It's a different kind of trust.
Okay.
And the statute doesn't say an irrevocable trust, there's no transfer tax. It doesn't give you the exemption. But we can exempt that tax because it does say if you transfer property by quitclaim deed, then it says the transfer tax is calculated on the actual consideration that changes hands.
yeah,
And if you use a token consideration of like $10, then you don't pay the transfer tax. Actually, it says if you quitclaim it and there's no consideration.
yeah,
I don't like the language "no consideration" because the deed's a contract. The
Yeah.
deed has to have offer, acceptance, and consideration.
yeah,
And sometimes the way we get around consideration is do a token consideration. And we only, where you say love and affection and $10, right?
Yeah.
The love and affection and other good and valuable consideration.
Yes.
But the money thing is a token consideration just to satisfy the consideration clause of a contract.
that's right,
But so if you transfer it by quitclaim and don't have any consideration, there's no transfer tax, which is
Okay.
how we do our asset protection trust.
so that would be how you would transfer it to the asset protection trust.
Now, if you wanted to sell the property, let's say you had a piece of property, you wanted to sell it to your child, you want to sell it to them at a really reduced cost. It's a $50,000 piece of property, you're selling it to them for 10.
Yeah.
You do it by quitclaim, you put the $10,000 in there, and the transfer tax would only be calculated on the actual consideration, which would have been that $10,000.
Yeah,
Now, we've
okay.
done that before for particular reasons, but, I mean, and you're not shortchanging anybody, because the statute actually says if you do quitclaim with no consideration, there's no tax.
Yeah,
But, and the theory is kind of this. Tennessee takes the approach that, you paid that transfer tax when you bought it the first time. Okay?
Correct.
And when you put it in a trust, I mean, you're kind of, not really, but you're kind of deeding it to yourself.
Yes.
And so they're not gonna make you pay it again. Now, a lot of states make you pay it every time, like Alabama. They have a smaller percentage, but you gotta pay the transfer tax every time.
Yeah.
And I have people with Alabama property, that becomes a surprise. I can get them out of it for the Tennessee property, but Alabama's Alabama, and so,
do I need to even talk about Alabama?
no, not really. But I'm just, as an example, other states don't do what we do, so that,
Yes.
I often thought if they ever realized how much money they weren't getting, they might change it, but
Yeah.
it's been this way for years. I don't think they'll ever change it, which is
Yeah.
good. It's an advantage to us here in Tennessee. We don't have to pay that transfer tax. And like, quick claims are usually, the most common use of a quick claim is when you have related parties.
Yeah.
You claim it to your child for no consideration,
Yeah.
no transfer tax. It doesn't actually say in the statute that if you give it to your child, you don't pay the transfer tax.
Yeah,
What
interesting,
it does is the way you do it and what the consideration is.
that's interesting.
Yeah, but Just follow the statute and you won't go wrong.
Yeah, there you go.
Talk to Joe across the street and do what he says to do, you know, then you're rolling the dice.
It's fascinating to see all the remedies that are available to move this assets around, to move your assets around.
And these are all, there's nothing new. There's nothing new here. It's the way it's been for centuries,
Yeah,
really. So,
quite quite a study.
so we are about a little more than halfway in.
Oh yeah,
Why don't you give
we
them the
still
number
got
again in case
766-9393 if you want to talk to Stan here this morning. 766-9393 is the number, and we'll be glad to take your phone calls.
I'm afraid I may have putting them to sleep with that.
Well, not me. Not
right.
me.
That's why I said it was
It's
down- right
kind of
down
right
your
down
alley.
my alley.
Yeah.
I like to talk about that stuff, and of course it always brings up little war stories that I've encountered across the years of selling real
Oh,
estate.
there's plenty. And
There are plenty, yeah, of little hiccups and what have you, and with these estates, and when people have it properly prepared. And I've run it since, of course, even before you and I talked, but even more so seems like since I've had the opportunity to talk with you. When I hear of an estate and the family's trying to decide what to do, and it's like I want to jump in and tell them what to do.
yeah.
I want to jump in and say, here's what you need to do. And of course I have to kind of hold myself back because they would kind of go through the process themselves. But just this week, a connection to a family that's going through this, they were telling me about what all they had to do. And I was like, look, you don't do what you think you're doing. You need to tell those folks to call me and let me give them a little bit of guidance before they really step in a big mess.
Well, I mean, if you don't understand it, that can happen.
And it's not that I'm giving them legal advice,
Right.
but I can tell them where to go and what to do to get that right
I mean,
advice.
it can go south if you're not doing it right.
Yeah, you sure can.
We see that happen a lot with our long-term care planning, where not changing the subject from deeds, but people hear that it's okay to give money away as long as it doesn't exceed a certain amount, but you can give it to as many people as you want.
Yeah.
And they start dwindling down Ann Gertrude's estate because they know she's going to go into long-term care, and they want to make sure that they protect that money, so they give that money away.
Right.
And then they come to talk to me about the actual long-term care and becoming eligible, and I got to give them the bad news that all that gifting away you did is going to come back and haunt us.
Yeah.
And they do it because, I talked to several people, and they said you can do this. And so, well, maybe you can do it, but they don't tell you the rest of the story. They don't tell you the consequences. You can do it, but there's some baggage that goes with that.
Yeah.
And if you do it, you can do it, but what's not advisable is to do it if you're doing it to prepare for long-term care in the near-term future. Then it's a catastrophic result. So, it's just a misunderstanding. It's just because they go on the internet and.
Yeah, you can think you're doing the right thing and making the right plans, but if you really don't know, you're kind of guessing, and it could bite you. It could hurt you.
I had somebody come in, and this happens every now and then, but somebody will do a do-it-yourself trust.
Oh.
Now, I mean, I'm not the kind of attorney that says you got to hire an attorney. You can't do anything on your own. I mean, if you want to do it on your own, do it on your own. Some things you can do with relative ease.
Yeah.
Some things it's a little more involved.
Yeah.
Like classic thing like. I wouldn't represent myself in a murder case. I wouldn't be as a defendant and the counsel at the same time. It's just not a good idea. But there's certain things you do. We got small claims court or general sessions court where you got a beef with somebody or didn't even pay you for something. You go in, you can make your argument.
Yeah.
You can do all that kind of stuff yourself. You don't need to hire an attorney for that.
Right.
But in this area, it's there are a lot of puddles of quicksand that you got to worry about. Just like the one I just mentioned to you. People get a misunderstanding about gifting away money, and they think it's okay to do it because the IRS says you can do it. The IRS is not TennCare, and TennCare is not IRS. As a matter of fact, one's a federal taxing authority, and the other one's a state bureau of TennCare that pays for long-term care. They're not one and the same. And one will say, yeah, you can give away $19,000 a year. Guess what? If you give it away $19,000 or less, you don't even have to file a gift tax return. Now, what they don't tell you is you can certainly give away more than $19,000.
Right.
If you do, you just have to file a gift tax return.
Right.
And what they also don't tell you is if you do have to file a gift, if you give away $50,000 and you have to file a tax return, you don't pay a gift tax. There's never a gift tax. It's just an informational return. It's like a one-page document.
Yeah.
And I always tell people, don't be afraid to file a gift tax return, because all they want to do is keep up with your lifetime gifts.
Yeah.
And they consider anything under the number, and that number changes from time to time. Right now, I'm pretty sure it's 19,000. But if you give away 19 or less, what they're saying is we consider that de minimis, we don't want to keep up with it, so you don't have to file a return. What they do is at your death, they're going to look at all the things you gifted away during life, and they're going to add that to your estate at death of what you have, and they're going to see if it exceeds the $13.99 million federal exclusion amount.
Right.
And if it does, now you're going to pay a tax, but it's not a gift tax. Now you're going to pay the federal estate tax, which is like 40% for every dollar over 13.99 million, or times 2 if you're a married couple. So that's why they do that. So don't be afraid to file a gift tax return. There's never a gift tax to pay.
Yeah.
And if there ever is because the way it works is this: you can gift something away, and the only person that ever pays tax on a gift is the giver of the gift. And the only time the giver of the gift ever pays tax on a gift is if the sum total of their lifetime gifts plus their estate at death exceeds that federal exemption allotment. And if it does, you pay a tax, and it's not even a gift tax. It's the federal estate tax.
Interesting.
So in this neck of the woods, we don't much run into that. But and people with those estates.
I'm probably not going to get in trouble with that one.
Yeah, right. But it's a misunderstanding that IRS says you can do that, and you can do it. But if you do it, and then you want to apply for long-term care, and they say on the application, the third to last question on the 16-page application says, have you ever given anything away for less than fair market value? The answer to that question is yes. I gave $19,000 to my sister. I gave $19,000 to my brother. I gave $19,000 to all my kids.
Yeah.
And they're going to add all those up, and they're going to say those are all divestments.
Yeah.
You gave that money away. Our presumption of the law is you gave it away because to try to artificially impoverish yourself. And their argument is, no, I gave it away because the IRS said I could do it. TennCare is going to take position. We're not the IRS. Every one of those are gifts, and we're going to hammer you with a penalty period for doing that. That is a common misconception. And I hate to, when I get in that position, I feel bad, like I got to tear the Band-Aid off real fast and say, listen, I got bad news for you. Somebody comes in and say, man, mom's ready to go in the nursing home. I've been working on her estate for the last 3 years.
Yeah.
I've been doing this. I gave the property away.
Yeah.
We've been gifting every year $19,000 or whatever the limit is to these people.
Yeah.
We've got her down to almost nothing. We're in great shape. We just need to apply. It's like,
Yeah.
you know what? I got bad news for you. And they get mad. And they get mad at me. And it's like, look, you should have looked for some advice at the time, because you just you read it or you see it and you just go with the street vernacular language, and it's not exactly what it says.
Yeah.
It says, IRS says you can give away as many people as you want in any calendar year, $19,000 or less, and not have to file a tax return. And then that's it. That's the end of it. But they don't say, but if you do that, it's a gift. I mean, a divestment is a gift. You give something away and don't get anything for it. And TennCare has their own set of laws that says if you give something away, now we don't care if you give it to your kid, we don't care if you give it to the church, we don't care who you give it to. If you divest yourself of it and don't get anything in return, we're calling it a divestment, and we're calculating a penalty period, and we're going to punish you for doing that. Because the assumption under the rules are that if you do so, and you do so within the last 60 months of applying for care, you are doing so for eligibility purposes.
Yeah.
Which is why 99% of the people do it.
Yeah.
You know, the theory is this: if you're in a nursing home or headed to the nursing home, or if somebody or a loved one is, and you say, well, gosh, if they're just going to get everything, let's just give it all away now. Let's give it to the family.
Yeah.
Well, that's exactly what they're talking about. And they have thought about that before the ink was ever dry on the TennCare Act decades ago, right?
Yeah.
So, you're not gaining anything when you do that. Now, if long-term care is not in your history or not in your future, or at least not what they call foreseeable, then you want to give away $19,000 to each of your kids, each of your grandchildren, and you can do that. There's nothing prevents you from doing it.
Yeah.
But the point is, a lot of people bend over backwards not to exceed the $19,000 because they say you can give that away. The only attachment to that figure is you can give that away and not file a return.
Mm-hmm.
But if you give away $25,000, you can do that too. You just have to file a gift tax return. Mm. Like I said, the gift tax return is not. People say if I got to file a gift tax return, then I got to pay a tax. Nada. No, there is no tax.
It's interesting, but again, when TennCare looks at it, they're going to look at it as something different.
That's right. People will often say to me, "Can I give my house to my kid?" And the answer is, of course. But if you do that, you might want to know what goes with it. There's some baggage that goes with that.
Yeah.
And it all depends on why you're giving it away.
Yeah.
let's say, you got 100 acres, and you promised your kid, hey, this 20 acres is yours, I'm gonna give it to you so you can build on it, you always wanted it. And sometime during life you say, maybe the kid wants to get started on his house now, and he wants to borrow money from the bank, and the bank's not gonna loan him the money because he doesn't own the property, right?
Right.
You say, okay, I'm gonna give it to you now. And you give him the 20 acres for love and affection, token $10, and you deed it to him. You can do that, there's nothing prevents you from doing that. Now, let's talk, but if you're gonna do that, let's at least talk about why we're doing it.
Yeah.
If you're relatively young and healthy and, the concept of long-term care is not even in the picture, there's not really any baggage.
Right.
But if you're advanced in years, you're having problems, mental or
Yeah.
physical problems, and it is foreseeable that you're gonna head for the nursing home in the next 5 years,
Yeah.
then it may not be the best idea, because that gift is gonna cause a penalty period. And a penalty period is a period of time where they won't pay, and the period of time that they won't pay can get pretty darn long if you're giving away real estate.
That's right.
Because you hear people talk about the 5-year rule, and they say, well, if you give something away, you gotta wait 5 years until you're eligible. That's not correct. 5 years is how long they can look in your history to see if you gave anything away. If you gave something away, they're gonna figure the penalty period is based on the value of what you gave away. So if you just gave away, $1,000 to your kid, the penalty period is gonna be de minimis.
Right.
But if you gave away a $2 million farm, it's gonna be 20 years.
Yeah.
There's no upper end to it. So that's another misunderstanding.
Wow.
5 years is not capped at 5 years. 5 years is just how long they can look backwards. That's why they call it the 5-year look back rule.
Yeah.
They can look backwards 5 years from the day you file a 10-year application to see if you gave anything away for less than fair market value. And they can sum all of them up. So if you've been doing this tax thing every year, they're gonna sum them up, and you're gonna get into a big lump of money. And
Wow.
the person you're trying to get eligible, you've just made things tons worse. Now, one step further, and that is in Tennessee, when you gift something away and you have a penalty period, you can cure a gift in a penalty period if you can get the asset back. Now, let's say that 20 acres you gave to the kid, and you say, hey, I'm trying to get in the nursing home, and they're going to hammer me with this huge penalty period because I gave that away. Can you deed it back to me? And the son says, sure, Dad, I'll deed it back to you. He said, I'll leave it to you in my trust at death, okay? But you'll get it, but you got to deed it back to me. You can deed it back to them, and then the penalty period goes away. You've cured the gift, but now you've got the asset, right?
Right.
So, but you can fix it. Now, when it comes to giving away money, like $19,000 to everybody, what's the likelihood of getting that back? Hey, I gave you this $19,000, can you give it back? Well, little Joey was in school and we had to pay the tuition, and Susie got braces, and there's just no hope of getting the cash back. I mean, maybe some. And even in Tennessee, you can even partially cure. So if you gave away X number of money and you get half of it back, you've shortened the penalty period because you cured the part you got back.
Yeah.
But getting money back like that, in my experience, forget it, not happening.
Yeah.
Land, sometimes you can do that. The kid will say, sure, I'll help you out, Dad, I'll deed it back to you.
Yeah.
But, and maybe not sometimes too. So,
Wow.
we talk about all that, and sometimes when you hear it in a story like that, maybe it helps make a little more sense.
Yeah.
But we avoid that penalty period like it was the bubonic plague.
Absolutely.
And sometimes we're stuck with it. And when we're stuck with it, there's actually ways we can make the penalty period work in our favor, if you can believe that. But there's ways, There's a lot of things that can be done.
An amazing world.
Talk a lot about that at the seminar.
Yeah.
So
You might want to remind folks of the seminar coming up.
It's about 5 till or so.
Yeah.
We're doing that September the 20th. Now, on our seminars, we do them about every other month now. We don't do them as often as we used to because we just stay too busy. And it seems like we're doing them all on Saturday. We started 2 years ago with a couple Saturdays here and there by popular demand. And it just went viral that was the better day to do it. We don't do them on a Thursday night anymore like we used to. So it seems like they're all on Saturdays. And we do Saturday seminars. They're at 10 o'clock in the morning. And the one coming up on the 20th is a Saturday, and it's at 10 o'clock in the morning. We call it Wills, Trust, and the Nursing Home. And that's what we talk about. And we're going to do it right here at the radio station in the back of the building. Now, I hate to say this, but they call it the Country Cafe back there. No, there's no sign that says it's Country Cafe, and it's not a cafe. So I hate to use it, but if you're familiar, if you're here from Lawrenceburg, this used to be a bowling alley. It's kind of a big old long building.
Yeah.
And that's where we are. If you come in on Saturday and you go to the doors at the front, they'll probably be locked.
Yeah.
okay? But if you come in the parking lot, you come toward the back of the building, there's a set of double doors back there, and that's where we'll be. And that's where the Country Cafe is.
Right under the big tower.
You know what? Right where that tower hits the ground is where those doors are.
Yeah.
So if you want to follow that, that's cool too. It's like
Yeah.
following the rainbow, I guess.
Yeah.
But again, if you want to come to that, we talk about wills, trusts, and the nursing home.
Yeah.
I used to call that seminar "How Not to Go Broke in the Nursing Home," but I
Yeah.
kind of softened the title a little bit because
Yeah.
I don't, anyway, what we do is we kind of do a review of what a will is and what a trust is, and will versus trust.
Yeah.
And the reason I do that is because what the main focus of the seminar is to talk about asset protection for long-term care.
Right.
And there is a solution to this problem, but the solution is a trust. And
Yes.
So I like to talk a little bit about trust to expose the audience, if they hadn't been,
Right.
to what a trust actually is. So anyway, that's Saturday the 20th. That's what, 2 weeks from tomorrow.
2 weeks from tomorrow.
So
And you will learn a lot.
if you want to, let us know that you're coming and how many. But if you can't do that, if you don't know until Friday night you can do it, just walk on in. The RSVP is loose. Here they got tables and chairs. We like to set them up, have plenty. We usually overshoot just in case because we always have walk-ins. And it's not that big a deal. We're not going to kick you out if you didn't RSVP. Just
Yeah,
come on.
yeah.
So,
Now, are you still offering something special for those who attend?
I do. I offer some incentives for if they want to go forward with a plan. We offer some incentives. So
Very good.
and they're pretty substantial incentives. So.
Very good.
Anyway, if you want to talk to me about that or get signed up for the seminar or anything else we talk about, give us a call at Pierchoski Estate Law, Pierchoski Elder Law, at 931-363-7222. Or you can go to my website. It's technically it's PierchoskiEstateLaw.com, but you can get there easily by typing in estateplanstand.com.
That's
that will
right.
take you right there.
That's
There
an
you get
easy
the phone
thing.
number. There you get the email if you want to ask a question that way. You can do that. I'll respond to all calls and I'll respond to all emails. Just not always at the moment they come in.
Yeah.
But we have time allotted for me to do that. So give us a call, go to the website, and we're here every Saturday morning. Every Friday morning
Every
from
Friday
8
morning.
to 9 for we call it Bulletproof Estate Planning. It's an interactive show. We didn't get any calls today, but you're welcome to call in.
Yeah, absolutely.
Same thing with the seminar. If you got a question, bring it with you. If you develop one during the presentation, we have an extensive Q&A after the presentation. I'll stay as long as it takes to answer every single question.
Estate Plan Stan, everybody. Stan Pierchoski with Pierchoski Estate Law, located in Pulaski, Tennessee on the square, next to the Star Theater there. And they got a production going on right now.
They do, Steel Magnolias. We got just a few, but that's,
Yeah.
I think it's September 19th through the 25th. It's usually Friday, Saturday, and possibly Friday and Saturday at 7 o'clock at night, and possibly a Sunday matinee. I don't know, I didn't bring anything with me, but it's coming right up. Tickets are on sale now.
Yeah, always enjoyable. And of course, Stan here every Friday, and thanks for being here again this Friday. Have a great weekend, my friend.
Always a pleasure, Joe.
All right, we'll see you next time.
This is WDXE.
Speaking of next time, are we off the air?
237
Just be sorry here.
Broadcast